Good morning, everyone. I'm Adam White, director of the C. Boyden Gray Center for the Study of the Administrative State. It's my pleasure to welcome you all today for a discussion of Congress, the courts, and the administrative state, or as we've been calling it, a discussion of delegation, non-delegation, and un-delegation. A discussion of the powers that Congress grants to the agencies, sometimes takes away from the agencies, and the role of the courts in overseeing that relationship. Now, as with all of the Gray Center's public policy conferences, today's conference has its roots in a research roundtable workshop here at the law school a few months ago, where a number of today's speakers presented early-stage papers on various aspects of the non-delegation doctrine. The authors discussed their papers with a wide variety of scholars and practitioners, and now they've produced significant draft law review articles, which are available today on the Gray Center's website. You'll also find mention of the articles throughout the program. We're grateful to the authors for all the work that they've invested in these insightful papers, and we're grateful also to the panelists for joining us today to discuss the papers and use those papers as a jumping-off point for broader discussions of Congress, the courts, and non-delegation. I'll have a few more thoughts to offer later today, but for now, let's get started with the first panel titled The Non-Delegation Doctrine, Reconsidered. Many years ago, in the case of Field v. Clark, the Supreme Court recognized a basic principle of constitutional law. Quote, that Congress cannot delegate legislative power to the President is a principle universally recognized as vital to the integrity and maintenance of the system of the government ordained by the Constitution. It's simple in theory, but of course it's proved far more difficult in practice, as 2 centuries of experience have taught us. In today's panel, we have 2 thoughtful scholars, CARY COGLIANESE and Jennifer Mascott, who revisit these issues in new articles prepared for the conference. We have 2 equally thoughtful scholars and practitioners, Alan Morrison and C. Boyden Gray, who have litigated or who are litigating the non-delegation doctrine in federal court. Their complete bios are available in the program. I'll introduce each speaker very briefly before his or her respective opening statements. And we begin with Professor COGLIANESE. He is the Edward B. Shills Professor of Law and Professor of Political Science at the University of Pennsylvania, where he directs the excellent Penn program on regulation. And if you don't already read the program's website, theregreview.com, I highly recommend it. He's the author of many articles and books. His most recent book is titled Achieving Regulatory Excellence. Please join me in welcoming Professor COGLIANESE.
Thank you very much, Adam. It's a delight to be back here, and I am always pleased to be on a panel with these wonderful colleagues that you've assembled here. I'm also delighted, by the way, the title that you have for this conference, because I'm working on a paper right now called Unrules. So I'm really interested in what we'll talk about un-delegation today. In this paper, what I am starting with are 2 propositions that I'm trying to see how the courts should reconcile them. One proposition is that agencies can write rules. The other proposition is that legislative powers cannot be transferred from Congress. Those 2 propositions, I think, are widely accepted. The challenge for the non-delegation doctrine is how to reconcile them, how to draw the line between permissible rulemaking and impermissible and unconstitutional transfers of legislative powers. And the approach I take in the paper is to try to move our thinking about that line drawing exercise from a unidimensional framework to a multidimensional framework. And I'll say a bit more about what that entails. But let me start by saying that the traditional approach has been to focus simply on whether the decisions that would be made by the lawmaker, either the permissible rule writer or the impermissible exerciser of legislative powers in the executive branch, the way to draw that line has been focused on one dimension, just the degree of discretion afforded to that decision maker through an intelligible principle. The challenge with the intelligible principle approach, that unidimensional approach, is that it's difficult to answer the question, how intelligible does an intelligible principle need to be? The court has expressly acknowledged that over the years it has approved very sweeping principles that suffice to make transfers of lawmaking or grants of lawmaking authority permissible rulemaking powers. And some of those are sweeping as regulating the public interest, for example. What's puzzling, though, is that if one goes back and looks at the court's decisions, say in Schechter Poultry in 1935, where the court did strike down a piece of legislation, the National Industrial Recovery Act, as violating the non-delegation doctrine, there actually are some principles that are reflected in that statute that require the president, before approving the codes that were authorized for the president to approve in that case, to find out that the codes meet the purposes reflected in that act, which are actually pretty extensively laid out. There's many of them. Fair competition, they may be somewhat vague, but they're there, and they're at least comparably sweeping as the delegations and principles that the court has approved since. So I'm left with, and I think all of us as academics have acknowledged that there's this puzzle. How intelligible is intelligible enough, and how do we square the court's disapproval of the National Industrial Recovery Act with its approval over the years of many other sweeping principles? I argue in this paper that the answer really lies in moving to a multidimensional approach to the non-delegation doctrine. Any grant of authority, any vesting of authority has multiple dimensions or features to it, one of which is whether that authority is legislative or non-legislative. So I think that's a necessary but not sufficient condition for going forward. And I think what most of the literature has done is to sort of assume if there's some grant of some legislative power, then we just look to see if there's an intelligible principle. But there's other dimensions as well. I think the scope or the impact of the delegation is very much important. What do I mean by that? A couple of things. One is, does the authority extend to one sector of the economy, two sectors, the entire economy? That's a different sweep of authority depending upon how broad the scope is. What about the type of actions that are affected? Could it be any kind of action that someone in the private sector is engaged in, or is it a fairly narrow or constrained set of actions? The level of sanctions that come along with the authority to regulate, those matter as well. And then, of course, we also have other ways of constraining that power, however broad or the scope of it is, of constraining that. One is the intelligible principle, but the other is a procedural constraint. And on every one of these dimensions, the sectors, the actions, the sanctions, the procedures, the National Industrial Recovery Act was an outlier. It encompassed and swept across all sectors. It authorized action to regulate all different types of business activities and prices, as well as workplace conditions. It even had in its statement of policy the conservation of natural resources. So the National Industrial Recovery Act could be said to have been one of our first environmental laws in the United States. So it was very sweeping, and when you contrast that with decisions subsequently, legislation subsequent to that, they're much more constrained on these other dimensions, even if the intelligible principle may be just as sweeping. For example, the Whitman versus the Clean Air Act at the center of the Whitman versus American Trucking Association. Sure, it was significant. It had implications certainly for the entire economy, but first of all, the statutory provision at issue in that case was only about setting national ambient air quality standards, which really only had direct implications for states, even if the indirect implications were broader. And the indirect implications really then only affected industries that were emitting air pollution. And the type of actions that the EPA was authorized to undertake was to set air quality standards or to deal with environmental policies, not to set banking standards, not to regulate fraud, not to regulate transportation safety. So it was fairly narrow. And what I think this multidimensional approach does is, one, it is more consistent with the actual decisions of the Supreme Court on the non-delegation doctrine basis. We can solve that puzzle about intelligibility. Two, I think it's more consistent with the text of the Constitution. Article 1's vesting clause reads differently than Article 2's and Article 3's. It says all legislative powers herein granted are vested in the Congress. The herein granted, I think we can't overlook, and what the multidimensional approach does is it says, let's look across all dimensions of the authority that is purportedly being transferred here to an agency or to the president and ask, does this look like the kind of authority that is herein granted to Congress? Is it the fullness of the Commerce Clause, as it was in Schechter Poultry? Or is it more limited, as in American trucking, and therefore it's a permissible one? I think this approach also helps provide greater clarity going forward, greater certainty about what the non-delegation doctrine means. I discussed briefly in the paper how I think this approach, which I've also called the non-abdication approach, that is, Congress can't abdicate by giving over the entirety of one of its enumerated powers to some other entity, that this approach resolves the case that's currently before the Supreme Court in Gundy, where the issue is sex offender registration and the authority of the Attorney General to make a determination about whether individuals who were convicted of sex offenses prior to the enactment of SORNA have to register. That's a really narrow delegation of authority. Even if the intelligible principle is hard to read in that statute, the other dimensions are quite narrow. I also mentioned briefly how this might play out with thinking about the relevance of the non-delegation doctrine with respect to emergency powers given to the president. If those emergency powers are so sweeping that they enable the president to undertake the kind of legislative powers herein granted to Congress, and they would sweep over the whole Commerce Clause, or they would take over the tax and spend power, then that would, it seems to me, be something to be concerned about on non-delegation grounds. But if you look at the statutes that this administration is invoking for its recent emergency powers exercise, they're quite limited in scope, narrowly confined to military construction, for example. They don't seem to me to be running afoul of the non-delegation doctrine, those statutes authorizing that power. There are other legal issues we could talk about with respect to that, but with respect to the non-delegation doctrine, I think the multidimensional approach, an approach that leads not so much to just thinking about whether there's some delegation of power to make rules, but rather to think about, are there full transfers of legislative powers herein granted in the Constitution, to thinking about whether there's a real abdication is the better approach in law and a better way of understanding what the court has actually done. Thank you.
Thank you very much. Right. Our second speaker today and our second author on this panel is Professor Jennifer Mascott. She's an assistant professor of law at George Mason University's Antonin Scalia Law School, where she teaches and writes on administrative law and constitutional law. Previously, she served as faculty director of the law school's Supreme Court Clinic and Administrative Law Clinic. She clerked for Justice Clarence Thomas and for then Judge Brett Kavanaugh. Professor?
Thanks, Adam, and thanks to the Gray Center for the Study of the Administrative State for hosting this event today. As CARY mentioned, it's very timely to be talking about delegation issues. I mean, this is a historical matter. Also, as CARY mentioned, for decades, Congress has been delegating very broad power, particularly to administrative agencies, independent agencies, as CARY mentioned, under the doctrine of what we call the intelligible principle, which basically has suggested under modern practice that as long as Congress is really giving any discernible instruction to administrative agencies that they can figure out in some way to follow, that's going to be a permissible delegation of policymaking power. It's also timely, as CARY mentioned, because as he said, the Supreme Court has litigation before it this term where it agreed to take up the question of is the modern doctrine on delegation appropriate, and as he mentioned, the case is dealing with the Sex Offender Registration Notification Act. I mean, one point of a little bit of disagreement with what CARY said. I think he mentioned that the delegation possibly that's being challenged in that case is a quite narrow one, and as he said, the question that the petitioner raised is whether the Attorney General could decide whether the Act's requirements retroactively apply to offenders convicted before the Act. If they do apply and the previously convicted offenders have to comply, then there'd be criminal liability for not complying. So some folks think that it might sweep in 500,000 people who otherwise wouldn't be covered by the Act. So I would actually suggest that that would be quite a broad delegation of power to be able to completely, without any standard, determine whether an Act retroactively applies. One might, but interestingly though, the government actually itself has not claimed that extent of authority. And so it's possible that the court could reach quite a narrow ruling in the case, because what the government has said is look at all the surrounding provisions. Actually, this act really constrains us. We don't have the authority to determine the act's retroactive application. It's comprehensive. It must retroactively apply. We just have the authority to figure out some of the mechanics of how it's going to apply. My take on the oral argument, which was back the first week of the term, is that a lot of the justices seem persuaded by that. So if I had to guess, I would say actually that there's not going to be really much seismic shift in the delegation doctrine this term at the court. The one thing that calls that judgment into question is that the case has not yet been handed down, which would suggest that it's not going to be a unanimous narrow ruling, that perhaps at least somebody is writing separately to encourage people to think more about the delegation doctrine, but I don't know. We'll have to wait and see when the case is handed down. Who knows when later this term. My particular paper goes back and takes a little bit different approach, takes more of a historical approach. It's going to be coming out in the George Washington Law Review's annual administrative law review issue later this year, and it's part of an issue that John Duffy and Aditya Bomzai from UVA are also writing in. And basically the theme of the issue is whether historical practices in administrative law shed any light on contemporary doctrines. And so particularly I'm looking at the early customs laws and delegation. One reason I chose to write about that is I had taken a very close look at the first Congress's statutes for another project that I did on the Appointments Clause, and in particular noticed that so much of the early legislating was imposing tariffs and raising customs revenue, I think in part because there was a narrow understanding at the time of what Congress was empowered to do under the Commerce Clause, and so raising revenue to pay off wartime debt would have been a core federal power. It was something Congress spent a lot of time on. Congress was concerned to pay off debt. And the customs laws are very, very highly detailed and specific, and so I was curious to go back and take a look at this paper at the legislative debates, and did Congress have anything to say about why they legislated with such specificity? The other thing that's interesting about the early customs laws is that really after the first statute regulating how government officials were supposed to take the constitutional oath, imposing revenue requirements on imports of goods was the first step that Congress took. Before establishing departments, before putting a Treasury Secretary in place, the members of Congress decided to get together and figure out how to raise revenue, in part because of the urgency of needing to raise funds. But I think the other reason that the issue interested me in wanting to write about it is because as people really along the spectrum within the administrative law community have gone back and looked at history. There's been some scholars who have taken note of the fact that sometimes the early congressional statutes seem to be written fairly broadly. And so sometimes the argument is raised, well, it's not just that Congress is all of a sudden under modern practice broadly legislating. It's not as though Congress and the court and the administrative agencies are straying from historical practice. It's always been the case that Congress can delegate broadly. And so some of the statutes that are cited are statutes giving the president the authority to regulate trade with Native American tribes or to put into place regulations to administer the payment of veterans benefits. So it's well-trodden ground with folks like Joe Postel, who's here, Philip Hamburger, Gary Lawson have gone back and looked at these things, and kind of in keeping with what CARY has said, a lot of what's going on and what has to first be looked at when one's looking at a statute is what kind of power is it that Congress is giving over or authorizing. And so these scholars have pointed out, look, we're not saying that any broad statute's a problem. It's certainly not the case that the executive or administrative agency can't ever exercise discretion in anything. If it's executive power that's being carried out, obviously broad executive oversight of operations within, by executive officials or supervising personnel or engaging in foreign affairs powers, things that would be, or carrying out the mechanics of benefits distribution where the veterans' benefits have been authorized by Congress, that those kinds of things would be within the core executive power. And so if Congress is putting in place a broad statute, there's no improper delegation of legislative power. The question is what's happening when we're talking, as Philip Hamburger talks about, with laws that actually bind the public, create new standards that the public or private actors or businesses have to follow, something that we would think would come more within the core of the legislative power. So, as CARY mentioned, the Constitution vesting clause, Article 1, suggests all legislative power should be vested in Congress. And so the idea is figuring out what that legislative power is. And once we know what it is, perhaps there should be a stricter delegation limitation on not allowing Congress to abdicate, as CARY says, and give that power away. So what my paper I think one of the core insights that it tries to demonstrate and suggest actually is that the delegation constraint is not just in the Constitution in that sort of formalist reading of the Article 1 vesting clause. I think it's definitely there, as I say, again, in figuring out what the legislative power is and making sure that Congress keeps and exercises that power. But I think also my research suggests that it's even more inherent in the whole separation of power system in total, and even this idea of federalism. In what's happening when legislation is put into place, and you can see this clearly in the customs debates, where the members from various regions of the country in the House of Representatives are really hammering out tough compromises. The duties that are put onto certain types of goods are going to intimately impact the economies of various parts of the country. And so you see the representatives who are elected by different groups, different geographic districts, different regions, really in an impassioned, very specifically motivated way because they've been elected and their political futures are at stake, representing the interest of their districts, or in the Senate, their states, in terms of how they hammer out these very detailed compromises of exactly what duties are going to be imposed on which particular goods. Should there be a delay in imposing the duty so certain states can get alternate supplies of how to get goods without having to pay tough tariff rates. Another thing that's talked about a lot is the importance of the elected representatives making these decisions to the point where the members of Congress actually decline to put into place tariff duties that just indefinitely are going to exist and continue because they don't want to hand over their power as elected representatives in raising revenue to the possibility that they can't actually in the future change those rates because through a veto and failure to override the veto in the House and Senate, such a small group of senators and executive could block what they want to do in terms of changing and putting into place new tariffs in the future. They see it as very important as elected representatives to make these decisions. Madison talks about how the states specifically gave up, for example, their power to impose tariffs and duties on other states and regulate trade in order to become part of the union. And so even though he's calling people to think about the interest of the country as a whole, he says we've got to make sure that every state's interest, every district's interest are thought about in these specific decisions that we make about how we're going to bind bind people in the economy. And then also in looking even more broadly than the customs debates, I looked a little bit at how just legislation or the legislative power was talked about in general in the first Congress. And so this desire to make sure that elected representatives are making more detailed decisions than we do under modern practice carries out into other areas as well. For example, I mean, lots of folks have written about the postal routes. Some of the senators thought that the decision to delegate where postal routes were going to exist was fine to give over to the Postmaster General, but at the end of the day, the House did not agree and put into place very specific, detailed specifications of where the routes needed to be, saying we're the local representatives, we know best what to do. There's also discussion about how when land is being sold in the Western Territories by land offices, you might think this is a situation where you need flexibility to change the price as the economy changes, leave that up to the administrative experts. No, members of Congress say we've got to decide what price the land's going to be sold at. There are constraints put on the amount of delegation that's given to determine where the nation's capital is going to exist. And so you see throughout lots of different areas of authorizing power, Congress really feeling as though it, as the elected representatives, needs to make detailed, tough decisions. The one last point that I'll raise is this does not in any way take away from a role for interacting with executive or administrative actors. Very soon after the customs laws are put on the books, the Treasury Department's created. Treasury Secretary Hamilton, who was seen as quite a powerful figure at the time, is nominated and put in place as Treasury Secretary. And so Congress utilizes his services and his expertise by instructing him to report back on not only what's the history of the kinds of tariffs and income that's been raised on taxing certain goods, but how should we pay down the debt? What can we do? How should we finance things? Even asking him for detailed legislative proposals. But they're very specific in terms of how they write the Treasury Act. They talk about how we don't want to tell him he can report plans, he can just prepare and suggest plans. I forget the exact term used, because they want to make sure that he is just giving proposals and that they are the ones who are amending the proposals and deciding through a tough vote what policies are actually put into place. And in fact, Treasury Secretary Hamilton, in a lot of the documents that he prepares for Congress, shows that he understands this limitation by saying, even in things that we might think are small areas of discretion today, going back to Congress and saying, we really need you to legislate and give us the answer on this, because we're not sure in this particular place how you mean these tariff provisions to interact and what rate we really should be collecting on this particular good. Or there's an instance where at one particular port, it's hard for ships to unload goods because of icy conditions. And you might think, here's an urgent situation on the ground, a decision can be made about slightly changing the location where the goods are unloaded. And the Treasury officials do not feel they have the power to make that determination and make that change and act in that area of need. They go back to Congress and say, we've really got to have you give us the legislative authority, give us the authority to change the place where these goods are unloaded. So I think that there's maybe not a specific precise line that can be gleaned from these debates in and of themselves, but clearly it seems as though Congress and administrative actors at the time had a much different idea of the share of how the domestic policy-making power was going to be made than we have today, and so my paper tries to unpack that a little bit. Thank you.
Thank you. Our next speaker is Professor Alan Morrison. He's the George Washington University Law School's Lerner Family Associate Dean for Public Interest and Public Service Law and Professorial Lecturer of Law. He leads the law school's efforts to increase pro bono opportunities for its students. He's argued 20 cases in the Supreme Court, including a case familiar to at least hopefully the administrative law students in the audience, INS v. Chadha. Most relevant to today's discussion, he is lead counsel in American Institute for International Steel versus United States, bringing a non-delegation doctrine challenge to the statute invoked by the president for recent tariffs on steel and aluminum. Professor Morrison?
Thank you, Adam, and thanks for the opportunity to be here. So you've already given one disclosure about that, my present litigation, but I go back a ways on the delegation doctrine. I've been unsuccessfully trying to litigate this case in the Supreme Court. I lost. I did not prevail in Boucher v. Siner on the delegation claim in Mistretta. I was also involved in an earlier round of Loving. I also that's the Loving Against the United States, and not Virginia. And some others as well along the way. I want to focus on CARY's paper. I agree with much of it, but not all. But first, I want to give a hat tip to Jennifer. Her insight about geography, I think, is very interesting. It's interesting. I'm not quite sure how it's going to work out, but it is certainly something to think about. And I hope somebody calls it to the attention of the people at the proper time. So point number one is, I agree that the intelligible principle is unprincipled. Got that out right, didn't I? It is not a test, it's a conclusion. And you can see it when you read the cases. The court simply announces there is an intelligible principle. In Mistretta, the court pointed out that the statute had four pages in the U.S. reports of conditions that had to be met. What it didn't do was to tell you how to decide whether somebody who commits tax fraud should go to jail for more time than somebody who engages in selling marijuana or somebody who engages in armed robbery. Those policy decisions were left entirely within the realm of the existing statutes to the commission. And so there was no explanation other than simply adding up the number of conditions that had to be met as to why that was satisfactory. The intelligible principle comes from a case called J.W. Hampton, which turns out to be a trade case. And in connection with my litigation, I went back and I actually looked at the statute there. The statute there was extremely narrow. The only power it had was to adjust tariffs to equalize the cost of production. That's a pretty narrow adjustment. And second, the only amount that could be changed on the tariff was it could be raised up or down 50%. Nothing else. That was all that could be done. Pretty hard to see that wouldn't pass almost any test. CARY's or anyone else's, including my own. CARY's paper has 7 factors, and I agree that it's a more useful approach. I urge him in the next round to go through some of the big cases and see how the test fares, because the proof of the pudding is in the testing. And if you don't test it, you're not going to find out whether it comes to sensible results or not, or how it would be applied in the future. But in our case, we've done something a little bit different, but similar. So we have 3 parts to our analysis. The first is what I call the trigger. That is what it takes to invoke the statute. In this case, the second part is remedies, and third part is checks on the executive. The statute applies whenever the president determines that the imports of any article may threaten to impair the national security. Now, national security is a pretty broad term, but Congress didn't stop there. The national security includes anything that affects the economy, including any industry or any part thereof. So if you're talking about expansiveness, they have a very wide range of choices. Of course, one of the difficulties with measuring the expansiveness is you measure it by what they did, in this case, steal, or do you measure it by what they could have done, which means anything in the economy? That's a question for CARY. But under my trigger question, the trigger is very open-ended. We decided not to fight principally with the government on whether this would come within national security narrowly defined. But given the expansive and cover anything, as the judge in the 3-judge court hearing said to the government lawyer, would this entitle the president to ban peanut butter? And the government lawyer hedged around it, and I got up in rebuttal. I said, Judge, Your Honor, I don't believe that the government lawyer answered that question. And she said, I'll ask him again. And she did. We got the same non-answer. So this looks like CARY's factors 2 and 3, more or less, in a somewhat different analysis. So the second part of our analysis is the question of remedies. What can the president do? And the answer is almost anything he wants in almost any way he wants to do it. So he can impose tariffs, he can impose quotas, he can have licensing, he can have an embargo, or he can have a combination of any and all of them. And on the tariffs, there is no limit on how much he can impose. And so he decided 25% for steel, only 10% for aluminum. No real explanation as to why he did it. the Commerce Department makes a report, but it's perfectly clear that the president is not bound in any way by what the Commerce Department recommends. And then 3 months into this, the president decided that Turkey needed a little extra tariff, so he doubled the tariff on steel imports from Turkey. Just so happened that they had a political dispute with the Turkish government at that time, had nothing to do with this. It also turns out that Turkey is about the 6th leading importer of steel. Its imports had actually gone down considerably, and the justification that the president said to raise additional revenue was insane because you wouldn't do it this way. There were lots of people who had a lot more money that you could put in, but those were countries that we weren't currently aggravated about. So he just did this. Point not being that that's any worse than anything else. It just shows that he has complete control over the question of remedies. Second aspect of it is he doesn't have to treat all countries the same. And in fact, he hasn't. He's given preferences to some rather than the others. He uses some as bargaining chips for negotiation for NAFTA. Others he uses for other negotiations. Perfectly permissible, can treat them any way he wants under the statute. Third, you may not know this, but steel imports are not one product. According to the tariff people over at Customs, there are 177 different tariff schedules, divided it into 5 or 6 separate categories. There are some products which are useful in national defense. Most of them are not. There are some products which are not made in the United States at all and which we have to import if we're going to use them. There are some products which are imported, but we have plenty of them already. There are some products which go into finished goods. Others are along the production. Everybody who submitted comments said you got to treat all these things differently because they really are very, very different. Nothing in the statute requires the president to treat them the same or to treat them differently. He can do whatever he wants. In this case, he said all steel imports are equal to each other, although there's an exclusion proceeding that allows you to get out of some of these, which in my judgment is, of course, doesn't save the statute, but it does indicate how unfocused the tariff imposition to begin with. And last, in most statutes we talk about today, the Clean Air Act and everything else, there are other things that have to be taken into account. What are the impacts? Does the president care what this does to all the workers who are going to be displaced? Does it care what happens to our exports? Does it care what happens to the cost of other goods in the United States? No, nothing matters. The president can simply disregard them, or he could take them into account if he chose to do that. And so we said it's hard to imagine remedies that are any broader than the remedies that the president can lawfully do here. And this is, I think, CARY's factors 4 and 5 in a somewhat different package. We tried to keep it down to 3. The last is, in a series of cases it began a long time ago, but recently brought into focus, it's clear that in situations like this, in which a department or agency of the government makes a recommendation to the president under a statute, and the president's decision is the final decision, that the president is not subject to the APA, and these decisions are not subject to judicial review. And the government has taken the position in this case, with which we agree, that these decisions by the president are not subject to judicial review, with one exception. He has to actually get a report from the Commerce Department, and he has to do it within the 90 days, not very difficult to comply with. And we said if he didn't do those, yes, there would be judicial review of that, but then he'd go back and do it again, so it wouldn't matter. There is no judicial review. And we say that's unprecedented in a matter like this, and almost all of the rest of the cases have judicial review of some kind, or all the rest of the delegation cases have it. Schechter had it. A Clean Air Act surely has it. Hampton had it. All the rest of them had it, including a prior case under this statute, which I won't bother you with today. And moreover, CARY's, I think, point 6, there were no procedures that are required. This is not an APA rulemaking. There's not confined to the record, no required statement of reasons. He can do anything he wants for whatever reason we want. And our argument is, no, judicial review is not required in every case to prevent there being an undue delegation. But it is there as a check to be sure that the Congress is making the law and not the president. And if nobody is there to step in and say, yes, the president's complying with the law, then the president must be making the law himself. And that, we say, goes too far. Along the way, people said, well, what's your test? How do you know when they've gone too far? And the answer is, if you can point to something that can't be done under the statute, then probably hasn't gone too far. But there's nothing that the government has been able to point to, and we made this point in our opening brief, in our reply brief, and an oral argument, that the president couldn't do. And peanut butter is just one example on the front end of it. But what he could do with peanut butter in terms of taxes and so forth and so on is the back end. And our view is that the case is like Lopez against the United States against Lopez, in which the Supreme Court stepped in and said, yes, the Commerce Clause is very broad, but there are limits. And as several places in the opinion point out, if the government can't tell you what the limits are, then they've gone too far. And that's where we are in this case, that there are no limits. And it's the combination, the judges on the court clearly understood that. Judge Kelly was the presiding judge, former Brooklyn Law School professor, said at the end, it's the combination that bothers me so much. There's no case like this where the trigger and so forth and so on. And you know, what is the end of it? The government lawyer didn't have any answers for any of those questions. And I think that's right. All right, let me just say a couple words about Gundy first. CARY, you said that your précis was the same as this paper, but it's not in one respect. Your précis talked about non-abdication. And I thought what you were going to talk about is Gundy, because Gundy's the classic case of abdication by the Congress. Congress was about to enact the SORNA, which required massive new registration of individuals who had committed sexual offenses. And the question was, should those federal requirements apply to people who had committed offenses before the act? The House said one thing, the Senate said the other. They went to conference and they couldn't agree. So what did they do? They punted. They said to the Attorney General, you decide the question. All right, is there an intelligible principle? Yeah, the intelligible principle is you, the Attorney General, get to decide. That's intelligible, I can understand it, but it's also legislative. There's no reason why Congress couldn't decide it except that they were abdicating their responsibility because it was a politically tough decision, and they didn't want to make it. And there is, of course, no judicial review because there would be nothing to review. The Attorney General could have flipped a coin and said yes or no. It's true that there are some variations that the Attorney General could do along the way. That is, he could have some of the people, it could depend in part on what state law was as to whether they're going to bring the federal. But the basic question of off-on was entirely up to Congress. The government said, well, the decision has already been made, and several of the justices point out, no. The last time this issue was before us, we said that it hadn't been made. Now you're trying to come back and relitigate that issue here. You're not relitigating that issue. They didn't just leave the mechanics because everybody agreed if the question was, how do you make the system work for those people who had prior convictions, but for whom it would be undue hardship now, that they could have left to the Attorney General. But the basic question seems to me that they couldn't have here. So, CARY, to the extent that you say that this would be upheld, I disagree with you because it's clear that this was done for one reason only. This is not like the Clean Air Act, where there were extremely complicated legal and factual and scientific issues. This was all about ducking responsibility, and that's exactly what they did here. And several of the justices understood that perfectly clearly, and whether they're going to do anything about it is or not. Is my time up? No. I don't know. Oh, I don't have any time.
Yeah.
Oh, how wonderful. It is up. All right. Well, maybe we'll come back and talk about national emergencies when we get back to that. Thank you very much.
And by the way, I should have noted that Professor Morrison's case that he described was recently the subject of a Washington Post op-ed column by today's keynote speaker, George Will. So,
do you have the briefs in the case on your website?
No, we can get them up there.
You can get up there, yeah?
Yeah, sure.
Okay. I think that'd be convenient for a lot of the people here, and then I can refer them to your website instead of other places. Thank you.
Well,
And the transcript, there's a transcript of the oral argument, too, yeah.
can you send those to me?
The transcript is up on the website also, I think.
good.
I'll send it to you all. I'll
Perfect.
send it all to you.
So our fourth speaker today is Ambassador C. Boyden Gray. He served for 4 years as White House counsel for President George H.W. Bush, and before that, for 8 years as counsel to Vice President Bush. In the White House, he wrote the original Executive Order 12291, establishing the modern framework for White House regulatory review. More recently, he served as U.S. Ambassador to the European Union and Special Envoy to Europe for Eurasian Energy. In private practice, he's often focused on issues of non-delegation, especially in the famous Whitman versus American Trucking case. He's now founding partner of Boyden, Gray & Associates, an adjunct professor at the Scalia Law School, and a senior fellow at the law school's Center for the Study of the Administrative State, which, you may have noticed, now proudly bears his name. We're glad that you could join us today.
Can you hear me?
Yes.
This is really a great pleasure because it's always been my view that this area of the law is one of the few places where the entire spectrum can be represented friendly. And I've known Alan for a long, long time, and we've been on opposite sides.
And the same side sometimes.
And the same sides, and it's really a pleasure. And it's a
My
pleasure
pleasure.
also for everybody else up here. And start off with where you were ending. What I have to offer here, I think I'm going to hold off until the end, but I want to repeat what I said at the last session, that it really does matter what Congress does do and can do. And when you point out that they were punting on Gundy, and that the members of the court know that, I mean, I think that's an important thing. Congress can certainly do its job and avoid ambiguity and avoid vacancy if they want to. And there's no reason why they shouldn't, and the courts shouldn't cut them any slack. That's really the point I want to make. And I probably, with the exception of maybe Michael Ullman, who's here somewhere, I'm probably old enough, probably the only one old enough to remember how Congress used to operate. Alan, you too. Used to operate, and there's no reason why it couldn't get back to where it used to be. If I had one criticism, Gary, of your paper is that I think you give too little birth to the canon, as opposed to the alternative, which is, I guess, to kick the statute out entirely or do nothing. And I think Gundy's going to end up with sort of a Sunstein-type constitutional avoidance by taking up Robert's hint at the very, very beginning, where he says, well, I like the Solicitor General's assessment of the statute, drawing lots of stuff that doesn't really support what he says the statute means. And I think that's where they're going to end up and not throw the statute out. I think it's not fair to say that, or imply that American Trucking signaled the death or the deafness of the doctrine, because it did involve the canon of avoidance. And the Scalia wasn't very clear that he was doing this, but he did take the hint from Seth Waxman to narrow the statute so that it avoided enough of the problem so that they didn't have to throw the statute out or even have to consider throwing the statute out. Waxman told me when he was interviewing the firm was not interviewing him. When he left his job, he was shopping around to see which was the best firm. He picked Wolf Cutthroat and Nitpick where I was, and we were all thrilled. But he told me during the interview that he worried more about this case than any case he had ever dealt with, and because EPA was so intransigent and wouldn't budge, he was terrified. I remind you all that it was a 2-hour argument. That was unheard of in those days. I think there have been 2-hour arguments since, Affordable Care Act, for example, maybe one or two others, but this was really unusual, an unusual case. And it's hard to, unless you've been involved in the Clean Air Act, which I have been, it's hard to read the decision get any sense for the impact. But I can assure you that the ozone rule, or the PM rule, the NAAQS that comes from those two pollutants, or deals with those two pollutants, has an enormous impact can have an enormous impact on the economy of the United States. I mean, if you are entertainment, you are essentially facing a construction ban. You can't expand, you can't build anything. You don't think that matters? I mean, maybe it does, maybe it trickles down to the state level, but it has a huge impact. Otherwise, they wouldn't have had 2 hours of oral argument, and Seth Waxman wouldn't have spent many sleepless nights over it. It is true, Guy, that under your rubric in the benzene case, there was no reason for the court to sort of attach a significance requirement, a hurdle, to shore up the statute. They didn't have to do it because, as you suggest, the case wasn't all that broad. But they did it. And it certainly gets transported, I think, into the discussion of Illinois BRIC, because you can't do anything more than necessary. And requisite, which is what the statute says, does not say, it says you have to do at least what's necessary. It doesn't say you can't do anything more than necessary. That's not in the Webster's definition of requisite. It's not in anybody's definition of requisite. And I do believe that, I can't prove it, I don't think Sunstein would ever admit it, but when he was at the Nerve Center, OIRA, in the first Obama term, he famously kicked back the ozone rule, which I think was a vast overreach and really would have had a huge impact, adverse, and perhaps enough to even endanger the reelection. He yanked it back, and I believe he did so because he knew it couldn't stand a judicial challenge based on no more than necessary. So these canons, these canons of avoidance, I think, are important. To bring it up to date, I love the line, my favorite line of Scalia's, almost in all of his work, is in the tailoring rule. This is the rule where EPA has to somehow adopt a certain set of rules to climate change. The typical big polluter is 250 tons of X, Y, or Z, but for CO2, that's just nothing, and it would have cost $6 billion to try to cover every installation that emitted 250 tons of CO2. So they changed it, the doctrine of absurd results, you all may recall, and said that 250 really meant 100,000. Now that's quite a stretch there. And then they asserted to the court that they had the right to go from 100,000 back down to 250 at any time they wanted to without any guidance from anybody. And this led Scalia to say, we're not going to sit idly by on the dock and wave goodbye to EPA as it embarks on its voyage of discovery. And that was, I think, a wonderful way of putting some color into the non-delegation doctrine. I think that it's important to recognize that the two new justices are onto this. Probably that may be why they were picked, I don't know. But they have written more, other than Justice Thomas, of course, written more about this than anybody. And I think if you all can remember, those of you who might have been here for the FedSoc annual conference, not this year, but last year, he was pretty blunt. He said, we all thought we could never get the Commerce Clause back from Wicker v. Filburn, and look what we did. We're getting it back, we're clawing it back, and there's no reason why we can't do the same with Schechter, and that's what we're going to do. We're going to kick out some statutes. He was very, very blunt. The unfortunate thing is...
He is Kavanaugh?
No.
Gorsuch.
Gorsuch. Kavanaugh was not yet on the court. This was Gorsuch. And the only sad news about all that is that he knew in advance that he was going to be making a provocative speech, And so he asked the Federalist Society not to transcribe it. So there's no way to cite it. Sorry. And you have to take my word for it if you weren't there. But if anyone who was there wants to quarrel with my description of the speech, please raise your hand and we can get into an argument about it. It was very, very blunt. So I think that the doctrine is, Sunstein's listed a lot about it, written a lot about it, but it exists, it's going to be used, it's going to be used in gun day, I believe, but at some point they're going to kick some statutes out, and I hope, Alan, that yours is one of them. And so good luck, as far as I'm concerned. Very good luck. I wish I could help you, but there's not, that court has exclusive jurisdiction, I think, over.
Yes, it does, yeah.
So there's nowhere else to go. He's got it, he owns it, 100% of it. It's all your fault if you lose.
I understand that. That's been my fault when I lost some other cases, too. I'm used to it.
I do want to say some more about the relevance of Congress to all this. I do believe that the problem has existed, obviously, for a long time. We go way back. Schechter goes way back, Hampton. But I do believe that the modern problem does have a trajectory that took off. And I've tried to study this. There have been some studies. It needs to be studied more. But I think it has to do with the Gingrich Revolution and the fact that he turned his troops loose to go home on the weekends, and now they have a 2-day week, which I think comports very well with what he wants to do or wanted to do and his successors want to do, which is pull all of the power into the leadership offices anyway. They don't want the members having anything to do with anything. And if you ask the average member, do you like what you're doing, he or she will say no. And the reason is not because they have to spend so much time raising money, which they do, but because they have actually nothing else to do. And so they kind of get sick of it after a while and leave. That's when statutes began to get unintelligible, or and they got more pages and less said. It's amazing how you can take up so many more pages to say so much less. But in the old days, you never would have had a Speaker of the House or Majority Leader, Minority Leader say, we have to pass this legislation in order to find out what's in it. That was unheard of back when I first started, but I'm an old fogey, so don't pay that much attention to me. But I'll just give you a couple of examples to sort of, if I can be very quick about it. There used to be markup sessions. And when I get into an audience like this, or I did at the FedSoc convention this last time, there were 500 people in the room. I said, does anyone here have any memory of something called an amendment to the third degree? And not a single hand went up. Not a single hand went up. But if you don't understand amendments to the third degree, you can't possibly understand how Congress used to work. And there used to be incredible arguments taking, not hours, but quite a long time to work out whether the governing document in front of you was actually an amendment already, which would limit the amount of amendments that you could have. I think this last year is the first year where there hasn't been a single piece of legislation on the floor subject to an open rule. That is, every legislation that's gone to the floor of the House has been a closed rule, no amendments allowed. Now, when I was first starting in practice, we had a rudimentary system of signaling to the senators when they were dealing with amendments on the floor. This is after 2 rounds of markup, subcommittee and committee, and they're still hassling over. And the hero of the moment in the passage of the Hart-Scott-Rodino bill, that's beyond the time anyone up here except maybe 2 or 3, antitrust statute. And Jim Allen was alive. He was the master of the Senate rules. The Senate rules are unique except for one other legislative body, the Alabama legislature. And he was an expert, having been lieutenant governor for 12 years. And so he ran circles around Byrd and everybody else, all the parliamentarians. He knew more than they all did. So he controlled the Senate for his actual career at the Senate. And in order to figure out how to settle a certain language, very technical language about the definition of per se violations of the antitrust laws, I was deposited up in the gallery. All this was contrary to Senate rules, but that didn't seem to bother anybody. And he would signal that some piece of paper was coming up to me, and I'd read it, and it was for my approval. Was it okay or not? And if it wasn't, I'd shake my head, and he'd go back and he'd signal to Mansfield, who was the majority leader, no, and Mansfield, but a few minutes later, up would come another piece of paper, and if I nodded, Mansfield would beam because he had figured out he'd triangulated that actually it was me who was giving the signals to Allen. But this is the way it works. You can't imagine this happening today. You simply can't imagine it. One other example, in the 1991 Civil Rights Act, which dealt with quotas, which were eventually knocked out, although it took nearly a decade of litigation to get that answer, it was very tightly fought. And at the very, very end, the operative language was taken out of the Americans with Disabilities Act, which was not a quota statute. And the next morning, the president calls me up and says, now, I want you to call Meg, that's Meg Greenfield, for those of you who can remember, and get an editorial in tomorrow's paper, no later than tomorrow, because we've got to get on top of this. Otherwise, you know who will stretch what happened entirely the wrong direction. So I called her up, and she said, well, if you could get it to me in an hour and a half, I'll print it if it's okay. An hour and a half later, I got it to her. 2 minutes came. She came back on the phone. This is wonderful. This is fabulous. Tighten your seatbelt. I'm going to get an opposition one tomorrow. And what a lovely ride we're going to have. Well, that kind of thing just doesn't happen today, where you're haggling over what are the precise words that are being used. We need to get back to that. And if we get back to that, a lot of this problem, in my opinion, will go away. And if you are watching, as I think you're right to say, whether this was a punt or not, Gundy, if you're watching as a justice, I don't think you need to cut Congress any slack whatsoever. They can deal in the most minute detail if they want to.
CARY, Jen, do you have any thoughts in response to the comments on your papers or what's been said so far?
I'm happy to say just a few words. I think there's widespread agreement on the panel that congressional responsibility and the members of Congress taking responsibility is a good thing, and I think we would all endorse Boyden's call for a restoration of greater responsibility by the first branch. I want to just say three things, I guess, in response to some of the comments where maybe there is some disagreement, maybe most of it on my part with others. So let me just take three points. First, on canons of construction. I didn't really spend any time in my oral presentation about this, but I do spend a little bit of time in the paper on the non-delegation canon argument. And I think that, the bottom line is that if it's really a canon of constitutional avoidance, then we need to be clear about what the Constitution demands and how close we're getting to it, right? And that's why I think, as Boyden mentioned, in the benzene case, I don't think the court needed to deploy the avoidance canon, because I don't think that the OSHA statute was anywhere near the lines that the non-delegation doctrine would draw, as I outline in the paper. It's a fairly narrow set of powers that OSHA has. Now, when I say narrow, I want to be clear. It's against the metric of those powers that are herein granted to Congress. It's not that OSHA doesn't have sweeping powers to regulate every workplace in the country. That is pretty significant. I don't want to suggest that from a substantive standpoint that that's trivial. But from the the non-delegation doctrine, I don't think it was a close call. I'd love to hear more, Boyden, about your thoughts about the avoidance canon in the American Trucking Association case, because I read that case as one in which Scalia passed up the obvious constitutional avoidance move, which would have been to construe the statute to allow EPA to consider costs, to overrule the lead industries case from 30 years ago. That would have been and that's, I think, really where Judge Williams was struggling with below, is that, there was no way to take costs into account, so there's no stopping point. So I would think if the constitutional avoidance canon was really at work in that case, we would have seen Scalia interpret it differently. At least that's what I remember everybody hoping to occur at the time. But anyway, that's on the canon. Second point would be on Allen's ducking responsibility test, which I love. The way you talked about the Gundy case as being a classic case of Congress ducking responsibility, and that's why you think Gundy should prevail. Listen, I think there's broad agreement about this as a moral or political policy matter that Congress shouldn't duck its responsibility. I guess where I would differ, and what I suggest in the paper, is that we need to look for some kind of judicially manageable test, and I don't know that ducking responsibility is going to be judicially manageable. And it's interesting, I think when I read Jen's paper, I see that there's been a long history, really, of disagreement about what Congress's responsibility is, and a long pedigree of arguments about ducking congressional responsibility. I think if you just make that the test, that's difficult. And I grant that my phraseology of the non-abdication doctrine might well lead one to think that I was inclined to favor that, but I meant by abdication a very formal understanding, in the sense that a monarch abdicates authority. Congress, to the extent that it has powers here and granted, if it abdicates, it gives up those powers. And I think, by the way, your argument in your current case is very much an abdication in that sense. When you look at a specific enumerated power that's been given to Congress, the power over duties and imposts and excises, right? This is what you are arguing Congress has given over to the president now. So I think that that in that sense, it's abdication by reference to the enumerated power. And then third point, just to say that, I think in some of Jen's comments and Boyden's comments, there's been reference to how significant some of the grants of authority are and I say significant as a policy matter. Boyden, I agree with you about the Clean Air Act and the impact that those ozone and particulate matter standards have. I think the EPA's cost estimates showed that those two ambient air quality revisions were going to cost more than the accumulation of all Clean Air Act regulations up until that point, just those two rules. So it's very much significant. I think it's also telling, by the way, that some of the more recent cases prior to Gundy that have arisen or have raised the non-delegation doctrine most clearly have been American Trucking and the benzene case, and both of those are dealing with agencies that do have authority over a broad range of industries. So on the kind of test that I'm articulating, multidimensional test, they get more of that dimensionality of the scope or impact than a lot of other statutes would, and certainly I think more than in Gundy. And Jen, I agree with you that certainly an attorney general decision that could have consequences for hundreds of thousands of people is not something to treat as trivial or to sneeze at, but it's not the same as the legislative power herein granted that's enumerated in the Constitution. I think that we can all say there's if we're going to replace this with a huge impact test, then how huge is huge? What if it only, SORNA only involved 50,000 people? Is that enough? You know, we get into those line drawing problems. What I want to say is that the benchmark should be to measure the scope and the impact and all of the other dimensions against what powers Congress has. And Congress, for example, under the Interstate Commerce Clause, has a broad sweep to cover all industries. It has a broad sweep to cover all types of actions. And the statute in SORNA, it's very narrow in that we're just dealing with sex offenders and their registration, not even all sex offenders. I mean, so that's nothing like the kind of scope, that breadth of authority that Congress has that defines a legislative power herein granted. So hope that clarifies where I'm coming from.
I do have a couple of quick points. First, I mean, I agree with Carrie. Certainly, there have been delegations that are much broader than what the delegation was argued in SORNA. So my call there would be they should all be reexamined, and obviously, particularly independent agencies should not be having the vast breadth of power and discretion that they have currently. The other point I just wanted to quickly raise is on this idea of using an avoidance canon in addressing the delegation concerns. I mean, if what we're talking about in Gundy is doing careful statutory interpretation and looking and seeing actually does the statute somewhere contain language that gives instruction as to how the registration should be handled, then let's do careful statutory interpretation and put into effect what Congress has done through its Article 1, Section 7 powers. But I think to the extent that over the years the Supreme Court or any court identifies true lack of clarity or vagueness or just a principle that just is not in the statute, I think it'd be a very dangerous, destructive thing for that to be addressed by the courts applying an avoidance doctrine that allows them to interpret the statute. And really all that it would do is take the delegation of authority, instead of being from Congress to the executive, to Congress to the courts. And so I would really place a call for a statutory interpretation to be done, and to the extent a principle is not given and elected representatives have not told us what to do, then there's just not that authority given to the administrative actor to act, and perhaps the court itself in that case needs to make a tough decision that the statute just does not meet constitutional standards.
Just one other thought on the way the court thinks about non-delegation. In a separate, very separate doctrine about agency independence, in the famous Morrison case, not Alan Morrison, but another Morrison.
Or Morrison versus United States either. No.
As the court was thinking through the independent counsel's independence, they said, they were more comfortable with the independent counsel's independence because she had such narrow policy discretion, right? So the independence issue was analyzed in light of the delegation of power, in a way. And I'm wondering, does that work in the other direction? Should the court, as they're thinking about non-delegation, think specifically about the structure of the agency that's receiving the delegation? Alan, you touched on this a little bit, but I'm curious what the others think as well.
Of course, in our case, it's the president who's getting it.
Right.
And depending on whether you accept the government's notion that this is foreign affairs, even though the impact is principally domestic, and even though the courts have been pretty clear that the president doesn't have any inherent authority over tariffs, which is what we've got here, I don't think that will help very much in this case. I just want to say one thing, Carrie. On the abdication, I meant to add, for no good reason, to my abdication.
Okay.
That is to say,
That's the
the
test.
Clean Air Act, it's perfectly understandable why Congress couldn't write those rules. There's a reason. One could argue about how much they should have left, but the notion that they were actually going to write those rules, even under Boyden's utopian view of what happened in Congress in the 70s, would not be realistic. But this one was was easy. All you had to do was pick the House or the Senate version, and that would have been the end of it. So that's for the second. On scope, importance, or whatever it is, the difficulty with that test is it depends on the level of generality at which you ask the question. That is to say, is it trade statutes? Is it all statutes? Is it the entire Commerce Clause, the foreign commerce? I mean, or is it just if this applied only to steel? The statute only applied to steel products. Would that have been any better? And my answer would have been no.
And my answer would be then it would be okay.
It would be okay, just steel products.
Yeah.
Okay. Well, all right. So we have a difference on that, but at least I mean the difficulty is Congress would rarely do that just for steel products, and then all imports. Well, is all imports narrower than all products? Well, who knows what it is? And so I just in terms of importance, I mean, take the Clean Air Act. Are some provisions of the Clean Air Act which have this massive impact constitutional, but the same kind of delegation to other portions would be unconstitutional? Because some of them are less important than the others, I just don't think that that's a judicially manageable standard.
Well, I agree with you, and that's why I'm very cautious about the huge impact. I mean, I don't want that to be seen as just like economic impact, but I want it to be benchmarked against a legislative power that's been granted in the Article 1.
I just don't see how you can do that measurement.
Well,
Scalia
the
talks about
National
that.
Industrial Recovery Act is very clearly the coterminous with the Commerce Power,
Yes.
right?
Well, okay, well, on that end, but how about moving it forward? That's the problem I have with, and I always thought that there were two problems, but one is they delegated most of the authority to private individuals in that case, although the president did have to put his rubber stamp on it. And the second is they had to enact a code of fair competition, which, as Cardozo points out, is not the same, is not just the other side of unfair competition, because fair competition could be anything affirmative that they wanted, and that's precisely the kind of question Congress needs to decide.
Boyden, Jen, either of you have any thoughts on this before we go to audience questions?
Well, I want to go back to one of the issues Gary raised about American trucking and why did Scalia avoid the obvious, sort of cost-benefit out, which is what Steve Williams was hoping for sure. He was a member of the panel. I think that, and I'll explain, he gets around to doing that indirectly, even though he doesn't admit it. But I think the really important other part of the case, which I didn't raise because it would have prolonged the discussion, is that Scalia is saying, no, the courts, or the agency following the courts, the agency does not get to decide.
Right.
Does not get to
Yeah.
decide. And that's for us to decide. So if you have
And
a
it can't narrow, it can't, saving construction can't narrow it, can't eliminate the problem. The agency can't eliminate the problem.
The agency can't engage
help or hurt it.
can't engage in its own forbearance and
Right.
solve the problem. So that's what he says, and it's important to remember, because if you have a genuine non-delegation case, there's no deference, there's no Chevron deference. Chevron is out, it's all in the courts. And that's a very, very important point, which I think is not necessarily relevant to this particular panel. But I think when he imports what you were suggesting was unnecessary in the benzene case, which is the notion of significance, he makes parallel the Clean Air Act and the OSHA statute, which I think is appropriate. But at the end of the day, if you're using significance as a test, how can you, as Steve Williams has pointed out and as Breyer has pointed out, how can you possibly deal with significance without ultimately dealing with cost? So I think it comes in through the back door, and one final note is that he says, oh, well, of course you consider cost-benefit when the standard is implemented at the state level.
That's right.
So it comes in through the back door.
Jen? Well, we have time for a couple of audience questions. If you raise your hand, a microphone will find you. We'll start right here with the first one, and then the second question will be right here in the front row.
So in thinking about the original reason for some of the delegation, particularly because Congress couldn't deal with the complex scientific questions, where you have sort of these complexities, such as for the NECs, why wouldn't one remedy be one that's been floating around Congress for a while, that it goes to the regulatory agency does the science, explores all the issues, but before it can actually pass a final regulation, it has to go back to Congress to make a determination. Why wouldn't that be a good remedy?
So do you mean specifically the Reins Act?
Yeah.
Okay.
Well, I think it would be a bad idea for the Supreme Court to adopt the Reins Act.
Boyden, I saw you leaning in. Did you have any thoughts on that?
Well, I think it's it's not a new idea, and I think Stewart and Breyer proposed it more than a decade ago. It makes a certain amount of sense, but it will never be adopted by the Congress, in my opinion. I just don't think they'll do it.
Second question here.
I had a question of Mr. Coglianese, or or others about the substance over form doctrine, where in roughly 1935, Mrs. Gregory versus Helvering, followed the exact provisions of the Internal Revenue Code, and the Supreme Court said, and then the Supreme Court supported the Internal Revenue Service in saying that this was a sham, because even though it followed to the letter everything that Congress had said had to be done to get some favorable tax treatment, it just was done to avoid the purpose of Congress. It seems to me that in that case, the Supreme Court took away the ability of Congress to collect revenues or to specify what, how taxpayers pay taxes, and gave it to an agency of the, an administrative agency of the executive. And how does that fit in to your analysis? Now, the substance over form doctrine, as you understand it, has never been commented on formally by Congress until a small section in the Affordable Cares Act in 2010. So did the Supreme Court basically take away, to an extent, the power of Congress to specify how the federal government raises taxes and give it to, not even the president, to the Internal Revenue Service?
So,
You
the answer is I haven't looked at that question with this in mind. I think that the present court would have come out a different way with that. Justice Scalia, were he on the court, would have said, the statute says this, the consequences be damned, and that's the way I see it. I do think, if my memory is right, that Congress has subsequently enacted a provision in the tax code that does enact, in a general sense, that if a transaction is for the principal purpose of tax avoidance, that at least it's a congressional imprimatur to look for form over substance, so that issue is probably no longer alive, because remember, in 30-something?
35 or something,
35,
right.
Tax avoidance was not a big thing. That is, we only had the Internal Revenue System for a few years, and people hadn't realized that you couldn't that the Congress hadn't caught up with what was going on. And so it may have been a transgression at that time, might not be able to get away with it now, but I don't think I'm going to try to rely on that in any of my current cases. But
Alan,
it's an
would you see a
interesting-
non-delegation problem in that statute?
In which one?
In the IRS substance
current
over
one?
form tax evasion provision you
Well, it
just
depends what
alluded
it
to?
says. It doesn't say just substance over form. It says if you determine that the principal purpose of the transaction was for the avoidance of tax, and you do this, then you can do that. So, you'd have to look at it and see whether, it seems to me there's lots of things that the IRS cannot do in that circumstance.
Yeah.
But that's a different question from whether it would be undue delegation.
Carrie, did
Well,
you
no,
have-
I'd love to push you on that, because I thought the test, which I agreed with, is there something that Congress can't do? And I think there's a lot of things on the tax power that Congress can't do.
Yes.
Right?
Well, that would, no, my tendency was to think that
Uh,
statute would be
the IRS
constitutional.
Yeah, that would
But-
be my,
but
on
without-
on non-delegation
I don't have it in front of me
grounds.
now, so
Right.
I
That would be
I
my-
would want to think about it. And remember, there's judicial review and all of that as well.
Right.
Well,
I don't think we have a non-delegation doctrine problem there.
Well, and unfortunately, we don't have time to discuss it if there
Okay.
were any more. We've exhausted our time.
All right.
Please join me in thanking our speakers.